Welcome to Show Money, the only show exclusively dedicated to the business of mixed martial arts. I'm Paul Gift, your economist. We're back with Jason Cruz, your lawyer, and John Nash, the man who knows everyone and everything in mixed martial arts and evidently curses at them every once in a while, we've learned. On tap for today is, of course, the Nick Diaz situation. And we have an update for you on the UFC antitrust trial. It's about to go into a phase where there might be a long gap where we don't have a lot of information, but we're going to sort of recap our take on what happened a few weeks ago. And then we have just a quick discussion about the Wanderlei Silva case. And so that's our day-to-day. It's been a while since we've been on the air, so hopefully we've got some good information for you to make it worth your time. So guys, what did you think? What did you think about the Nick Diaz situation? It was a big day on Tuesday. And first off, did you think it was, say a week ago, did you think it was going to cross 100,000 signatures? For those who don't know, that's where you get your White House response.
Yeah, someone had put a petition up to try to get 100,000 signatures. If you get 100,000 signatures, the White House is supposedly supposed to respond. In small print, they don't have to if they choose not to. But I was thinking it wasn't going to happen. It reached 100,000. The odds are the White House doing anything seems very slim to me because they really have no say in, they're not going to interfere in state government. There's, we have separation for reasons but it's kind of big because just reaching 100,000 symbolically, this shows major interest and major disappointment in how the Nevada Athletic Commission acted. And this is unheard of. This is unprecedented that this kind of public reaction from the fans, this much obvious anger towards a decision. And so if you're an elected official and you're assigning people to a position, you do not want those people that you assign to a position in government to lead to backlash and negative press. That's the last thing you want. So it's not going to automatically lead to, I imagine it doesn't lead to Obama instantly saying, I'm going to overturn it by, a presidential fiat, but it will lead to a lot more interest, attention, and pressure on the current governor and the current members of the Athletic Commission to actually respond to it. At least that's my take. Jason?
If Obama does overturn it, then I would want him voted in for a third term, personally. But Jason, so what's your take on it?
Well, we're talking about complete revolution here. Well, I think that two things that come out of this. I believe on either late Monday or Tuesday, he needed 18,000 more signatures, and he got that within, maybe over a day, just over a day, which is great, and which also shows the great grassroots efforts that MMA fans do have and can have to come together. It also shows the popularity of Nick Diaz. If it was just some other low-level guy or some guy that the MMA crowd did not like, it wouldn't have passed. Now, I think, as John points out, federal and state law, the federal government's not going to intervene on a state administrative issue. Rather, they probably would just kind of defer and just have the state perhaps look at it again. But what I think it could do for local officials, like when we're talking in Nevada, is that politicians that could latch upon this in efforts to rectify the situation and maybe affect change for the future. I think that if you are able to have that political push from this action, from the action of the signatures, you might see some change locally.
Yeah, politicians probably don't like having their decisions put under any type of additional scrutiny. But I'm with you guys. I think it's more of a long-term thing and really shows how passionately people cared about this. And it's just good that it happened as opposed to not happening if it stalled out at 85 or 90,000. So when you were, let's go back. It would be interesting to get your two different takes on it. Let's go back to the actual hearing itself. I put out on the internet what I thought about the hearing, but what's your take on what went down in that, as we were constantly reminded, administrative hearing and not a criminal trial or a civil trial? But what was sort of going through your head as it happened, and what was your take once you had some time to process it?
For me, I would say when I was watching it, I didn't watch it originally. I just saw some tweets about it. It sounded ridiculous. I go, this sounds so damn ridiculous. I got to watch it. So then I watched it. I was pretty amazed because it just struck me as inherently unfair, inherently undemocratic in the sense that we have even though it wasn't an official court trial, that if you present evidence that you've taken 3 tests and 2 of them say you're clear and the third says you're guilty, that seems counter to any rule in civics class I ever took, that third test is the one you're going to accept. You know, that's the one thing I got from it.
Especially when it's in the middle.
Yeah, in the middle. Apparently he got really stoned, drank a ton of water, got stoned again, drank a ton more water, and did not die from drinking 80 cups of water in a half hour. Apparently that's what happened. And even if I can't say the WADA test and the Quest Lab test, which is the superior test, because I don't know exactly what they did, but when the commission's saying that the WADA test is the superior test and yet you're still throwing those tests out, that brings up another flag. I think people are too much preoccupied that it was marijuana, and the fact that it's marijuana shouldn't matter. The fact that, that a lot of people think marijuana should be legal, and medical marijuana, and they think it's a witch hunt against marijuana, that's the minor issue in it. To me, the bigger issue is that they ignored 2 tests that cleared him and only took the tests that said he was guilty, which was, if you're gonna, there's a preponderance of guilt and preponderance of doubt. I think that creates preponderance of doubt right there.
Yeah,
that was my take, and nothing changed since then. It only got reaffirmed.
And there was so much focus on the third test, and it's like, what was the guy pounding water like right before going in to fight Anderson Silva? It was like, let's do this. Or did he have a joint right after fighting Anderson Silva and then pound water?
Yeah.
Jason, so what was? Sorry, go ahead.
Oh, I think that one thing, it takes on the characteristics of being in a court, the administrative hearing, and so it was ran by a lawyer, Ms. Lundvall, and Nick Diaz was represented by lawyers, but still it didn't have. I mean, it did not go by the rules of court, which seemed counterintuitive to what was going on. I mean, you look at the fact that Nick Diaz was taking the 5th, and Pat Lundvall, who's a seasoned litigator, doesn't know whether or not the 5th Amendment applies to administrative hearing or a civil matter. I mean, that whether or not that's gamesmanship is kind of up to us to speculate. And the fact that there was no opposition, real scientific opposition to the presentation of the evidence by Diaz's lawyers also presents really some concern there as well, and kind of lacks when you look at the actual penalty that Diaz faced. It kind of lacks. You kind of wonder, well, how did they come up to this penalty when you look at the evidence and weigh that? So I mean, it really does. You do scratch your head when you think of how the commission comes up with the penalties. Just are they doing it in random, or are they, what's going on? And you see the Diaz penalty in light of what they did with Wanderlei Silva and what's going on with his appeal is being remanded, and actually in 2 weeks he is supposedly supposed to be before the commission again. So we'll see what happens at that point. But I think for overall the hearing itself, it just you look at there was seemingly confusion there because Diaz's lawyers were trying to object, and the commission is saying, well, this isn't really a court of law, but yet they're having people take oaths under testimony under oath. It really seems like it's something that needs to be done about it.
Yeah, it feels like it feels. I don't know how to describe it or what I was thinking as it was going on. I watched it like a day and a half later because I had class literally all day on Monday and then the first half of Tuesday. But so let me read you let's put you guys, if you don't mind, in commissioner roles right now. I'm putting you on the spot. We did not plan this in advance. But you guys, you're now Commissioner Cruz and Commissioner Hey Not the Face. Okay. And your evidentiary standard is to base findings of facts on an evidentiary standard in which the evidence, when considered and compared with that opposed to it, has the more convincing force and produces in the minds of the members of the commission a belief that what is thought to be proved is more likely true than not. And that is your standard. All right?
Yes.
And now you have the floor, like they did, to discuss and come up with your punishment, if any. But
well, I think we have to weigh the fact that one test that he failed on is not the test that we consider the gold standard. On the same hand, we don't like the guy, so I'm going to give him 5 years. I think that's fair. But that seems to be that seems to be the weighing process. I'm just, I'm trying to give the mind of a commission member. So, not like his attitude, so we got to weigh that and the fact that he's probably he has a preponderance of innocence in his case, but we don't really care about that because we don't like the way he's looking at us.
And what would you have said if you were the fifth guy on that panel?
If I was the fifth guy, I would probably go, "You guys freaking nuts? What's going on here? This is crazy."
Yeah, I mean, it's funny because the standard, it seems to be more probable than not, and if you weigh the evidence, I mean, and what seems to have happened here is that they weighed the evidence as well as the demeanor of the demeanor and testimony of Nick Diaz, which was nothing. He took the fifth, and the demeanor of his attorneys, which was adversarial, and they weighed those factors into the penalty, and which seems what not to do here. You should be just weighing the evidence as to whether or not he failed the drug test. What does the evidence say? It was clear based on what was presented that there were the tests there was a disparity in tests. So I don't know how that equates to 5 years and a third of his purse.
Yeah, it seems like. Go ahead.
Adversarial attorney. Imagine that. But no, the other thing too is I think they also took. It seems strange that they implied that because he didn't ask for a B sample test of the second test, that seemed to be him accepting that the second test was accurate. And to me, it's like this lawyer did the right thing. Like, why go a B sample of the failed tests when we have two other tests that already prove that seem to prove that test is the outlier? If we accept the B sample, that seems to be us admitting that the B sample is an official test and it was actually accurate. So you're in a catch-22. They're trying to put him in a catch-22. You're not having the B sample tested, so. How do we know that that's not the official test? Well, we already say that, and by not throwing that test out, you're screwed because you didn't get the B sample. It's a no-win situation for them.
Yeah, and they didn't seem to like that he could possibly get out of it without the B sample, almost like they didn't like how that would be going forward, something like that.
Yeah, if you're going to argue the sample's already contaminated, then there's no evidence. I mean, there's a strong possibility the B sample's going to fail too. And if that's the case, why would you even want to test it and agree to have it tested and accept that the A sample's already? That means it seems to be implying that you're accepting whatever happens to the B sample is accurate. As an attorney, you'd never tell your.
Yeah.
No, it was a great decision by them, and it's weird. It's like more probable than not. I mean, because we all know Nick Diaz, and the second you say more probable than not, you're like, okay, yeah, probably. I mean, but if you look sort of objectively on what evidence is there, I don't know how you could possibly say more probable than not, unless it felt like they were using their ability it felt like in the words the focus was that you had a failed test, but in the reasoning they used the ability that because he didn't testify they can do this adverse impact. And that's one thing I wish I could go back and take back in the thing that I wrote. There's two things I've written at Bloody Elbow I wish I could take back, and one of them was this, right, which was talking about a sort of a perverse law, and from a criminal perspective it is, but yeah, from a civil perspective, you tell us, Jason, isn't it? If you don't testify, you pretty much lose if you're in a civil case. Is that correct? But it feels like what they did is they took civil law and applied it to what they constantly kept saying was a different thing at administrative hearing. Right?
Well, I mean, you can't. You do. There is case law out there where you can take the fifth in civil lawsuits and or civil cases, and that does not necessitate whether or not you are guilty or not, and it should not be inferred that you are guilty. And in fact, in civil cases, people, plaintiffs or witnesses do not testify in cases for a variety of reasons, and usually in those cases you might infer the opposing side might infer something, but you should not, as a trier of fact, as the judge, as the commission who is going to render the decision, you should not infer from someone not testifying that they are guilty. And it seemed as though you could make the jump here in this situation, that the commission decided the fact that Diaz would not comply with their questions under the guise of the Fifth Amendment, that hey, he must be guilty, and the fact that they are saying that it's an administrative hearing kind of gives them the broad stroke to say, well, we can do that because this isn't a civil case because it's an administrative hearing. So I mean that's my speculation on what.
Actually, that really drove me nuts too during that, because what you're bringing up is he's pleading the fifth, and probably for good reason, because I think Diaz himself, Nick knows, he says stuff off the cuff that gets him in trouble. So he's like, I'm going to plead the fifth. And he's already handing it over. It's like, I can plead the fifth, and you can infer that whatever you want on that. But even inferring that his answer might not be the accurate one to all their questions, it still has to outweigh the fact that 2 tests came back clear.
Exactly.
And even that, so I don't think, even if you say, okay, we're going to infer that his answers are not or answers that are going to incriminate him more if he answered, that's still, you have to sit there and weigh and go, is that going to be enough to outweigh the fact that 2 tests he passed, and the middle test, he did. Only the middle one he failed.
I don't think that's possible at all. It makes no sense to me.
So, I mean, I can understand him inferring that it's damages his case if the case came down to 2 different WADA lab tests, and one of them he passed and one of them he failed and refused the B sample. Well, then now it's it's a balanced scale. It's okay. Now we're going to infer, because you wouldn't answer our questions, that it tipped the scale just enough. We find you that you did fail the test. But in this one, the preponderance is definitely on the side that he probably passed the test. That was the outlier, the middle test.
Absolutely.
That's my layman. My one thing too, and I will get your thoughts about this. I have one issue with this case, is I think it's, in a weird way, I wonder if we're almost too preoccupied with Nick Diaz on it, that the fan support and interest and love of him makes it focus solely on him and the passionate. A lot of people are very passionate about marijuana use, solely about him and that issue, and ignores the fact that this is actually a much bigger issue. This is something that can happen to any fighter that goes to Nevada or another commission, can be treated this badly. And instead of being looking for a solution just for Nick, people should really be looking for a solution that will protect anybody in the future besides just Nick Diaz. And that's my one complaint, is I think it's almost too narrowly focused. No one's, we're going to fix this one solution. What happens to the next the poor fellow who's not nearly as popular and maybe gets busted for something not nearly as popular as marijuana? That guy's out of luck, because we're starting over from square one. We didn't fix the problem.
Yeah, I agree. Although I can speaking for myself, I'm in this writing a decent amount about it because of how I feel about what they did, not the situation, not weed or Nick Diaz. Because honestly, I liked watching Nick Diaz fight, but I wouldn't have called myself a huge Nick Diaz fan, just because I don't really like how he carries himself before and during fights. After fights, it's fine. But so I'm not the type of guy who would have jumped out to support Nick Diaz super fast unless it was something that really seemed to be an injustice, and so I agree with you. I think it is getting a lot of play because Nick Diaz and marijuana, but I think it also has people in it who truly just think something wrong happened.
All right. I think, wow, we covered an issue there. Did we
so
finish?
really quick, actually, though, what are the one final thing, though, right, is going forward. What do you think? I mean, I think we all can agree the penalty was absurd. And I think we can possibly agree that maybe some fighters would want to stay away from Nevada, like you've already seen. But what about going forward in terms of? I highly doubt there's going to be a rehearing on it. I don't know, but it seems like the next step is the lawsuit, right? So any thoughts on that going forward about what we should expect or what you think might happen?
So I'll chime in real quick. I think that they have to render a actual written decision, which they have not done yet.
Supposedly, yeah.
Supposedly have not done yet. And then at that point, Diaz's attorneys can either ask for a rehearing within 10 days or file that lawsuit in Nevada State Superior Court, I believe, or district court, in state court there, in Nevada. And so, I think I think the next step will be lawsuit. Unless they believe that there's the inference that UFC is going to be helping Nick through their retained attorneys at Campbell and Williams. So we'll see how that all pans out.
Yeah, I don't know what's going on with Campbell and Williams, that they're taking over for him now, or are they just helping out with research, or they're taking? Yeah, I mean, it's good. He's got extra muscle, at least even just politically, image-wise. That looks good. That the UFC is saying that they're supporting him because they're major players. I imagine they're major players in Nevada politics. I'm just guessing. I think they have some clout there. I don't know. I'm going to go with Jace. Whatever he said, I agree with him.
Yeah, the Campbell Williams thing surprised me a little bit. I just didn't think the UFC would want any appearance of sort of crossing the Nevada Athletic Commission. I mean, maybe you guys have a different opinion of it, but I know that Dana White will yell about like Keith Kaiser back in the day, right? But when it comes to actual commissioners, I didn't think that they would want to put out the appearance of crossing them.
Yeah,
I'll go ahead, John.
I was just going to say, yeah, it's funny. Everybody used to make fun of Keith Kaiser in hindsight. Looking back, I know a lot of people talk about they kind of, at least they miss him. You think he was a lot better than he was given credit at the time, especially now you compare him to what came afterwards. I think part of it was just me and my personal opinion, based on it, is just the reaction was so big that they felt, why not side with your fighter when everybody is so antagonistic towards the NAC? Why make it so your fighters look at you as though you're not backing them up anymore? And it's a simple, to me it was a simple solution for them, a simple choice. It's like on this side, in this individual incident, we should look like we're supporting our fighters because we don't want to let them out to hang on just this case. That's just me.
Yeah.
It's interesting balance there because the UFC is lobbying the NAC and among other commissions for different penalties on PEDs, and here they are now in this position where it looks like they're going to be opposing them in some fashion. I mean, whether it's indirect or not, I think that it appears as though they feel like Diaz was wronged in some form, and it looks like they're going to back him up. And it looks good, like John said, it looks good PR-wise for the UFC because it looks like they are, on the side of right this time.
All right, guys. Is there anything else you want to add to this? And I agree with you guys completely. Yeah. But the second you say fixing fights, then the UFC's like it's on, like Donkey Kong.
That's a story in the future. That'll be our third segment. I guess right now you made a trip to like an absolutely, I don't want to say pathetic human being, but let's say a very passionate human being. You made a trip to Vegas to go see the court because a lot of happenings are going on in the Zuffa, the Kung Lee et al. Versus Zuffa LLC lawsuit. So we should give a rundown. If you want to give us a rundown on all the decisions lately and also what you saw in the courtroom.
Absolutely. Wait, that's pathetic? Jason was making fun of me on Twitter, and now you're making fun on air, huh?
Oh, nothing. I said passionate. I misspoke. Pathetic.
You misheard. It was passionate.
Yeah, it was passionate.
To me, it's one. I love Vegas. Two. This is honestly professional development. Also, in addition to writing for Bloody Elbow, right? To follow an antitrust case. Well, I used to do the expert witness stuff on these cases, right? But you'd always get them around class certification and then going into summary judgment and stuff like that. So I've never followed one fully from beginning to end. So it helps when I'm going to take these things in the classroom. Later this term, when we talk about exclusive dealing, we're going to talk about UFC. And if you like that, come get your MBA at Pepperdine. And when we talk about tying, we're going to talk about Al Heyman.
If you like combat sports and antitrust law, come to my class. Where it all comes together.
Exactly. But so no. So the two major things that happened, right, were the UFC's motion to dismiss, and then they had a motion for a extra strong protective order instead of just confidential, a highly confidential designation, where they wanted to keep certain documents from being accessed by plaintiff attorney Rob Mazie, who happens to be a real estate lawyer. For those who, I forgot we were off air. That would have made perfect sense. We were off air joking about that. Sorry. And the fighters, and it would have kept it from some of the fighters, I believe. And so those are the two motions, and I'm going to ask you in a second, John, if you have more inside information as to why Mazie ended up not being excluded, because the transcript has officially been posted, but you can't access it without paying, like whatever, $300 or $400 until.
We have to pull our money. Let's start a collection. We're gonna start a PayPal collection, people.
Until January. I don't know if you've talked to Mazie. Have you talked to Mazie? Let's just start there. Have you talked to Mazie about? Okay.
Not about this case, I think so. Yeah.
So anyway, so then going back to the motion to dismiss, it was cool to go out there though. It was really cool. I got to meet the attorneys from both sides. There were a ton of them. I met the main ones. All of them are really nice.
That's the funniest thing. That's the funniest thing. Yeah, they're really polite guys. I get along with both sides. I've talked to them. Very nice guys.
Yeah, Rob Mazie is incredibly nice. And then who was the other guy? Bill Isaacson. He had a lot on his mind. Bill Isaacson, had just done a trial like earlier in the day. He was doing it all week long earlier in the day, and then he finishes a trial and comes up and does this motion to dismiss. It's like, how do you keep all that information straight in your head? And so anyway, we get in there. I get there early because I always get to these things really early to make sure there's no issues, and there ended up being an issue. But I'm talking to security guards in advance. Oh wait, maybe I shouldn't say this. I don't want to get them in trouble. But they're like, Judge Boulware, he's never on time. You can expect this thing to start late. The guy is never on time. So I expected it to start late, but then we ended up starting. Then it ended up getting postponed for another reason. So we started about an hour late. But it was cool to meet everybody and see everybody. And then the hearing starts, and boom, right off the bat, the judge is just sort of tearing into the UFC side. It literally went like this. The UFC guy said his first statement. The judge interrupted him in his first statement. It was like, well, what blah, blah, blah. And it was on. And it was one of those things you just got the sense like, whoa. That the sense that you had in San Jose, that the plaintiffs were really struggling, that same sense came here. And the main reason seemed to be that there was this focus on at this stage. That's kind of the big thing. The judge is saying, look, right now I have to take everything they're saying as given. So you can dispute it later if you want, but right now I have to take it all as given and say, if I believe everything they say, is this enough to move forward? And that was his real focus. So that kind of might bode well for the UFC down the line when he has the chance to not believe them, but there were some other things that didn't quite bode well for them, and I'm going to quote one for you here. There's this thing that the plaintiffs are trying to say that the contracts are in perpetuity, right? And one statement we got from the judge was he said, if the UFC has the right to match a contract after it expires, he's like, his direct quote is, that's not a 2 or 3 year contract, that's forever. And me having worked on these before, when you hear that statement, that's huge. If he really believes it, I don't know. But if that's what he believes, or I don't know if, he could be probing and testing you. But if that ends up being what he believes, then that's a really strong statement, because one of the things the UFC is going to have to do down the line is show that these contracts are not forever. Right? So we got that, and he made a surprise ruling. that given that he took everything that the plaintiff said sort of as given, that it was enough to move forward, and we got that ruling right away. And so yeah, we now we get whatever, a year and a half of discovery, pretty much.
Yeah, everybody's excited because the everything about the disclosure, and it's like people are gonna have to wait. It's gonna be a while. But also the fact, it's to get on the subject, and Jason, I'm sure you know more about this, Jason, is people seem to think that because it's, you know, that none of the discovery is going to come out, and that's not true. If it goes far enough, they have to submit evidence. Guess what we're going to be able to see? That submitted evidence is going to have pieces that are going to tell us what that discovery revealed, and then the plaintiffs will file and say, oh, this is the percentage of income, the revenue that went to the fighters, and the UFC is going to have to file something else that says, no, this is how we got that was different. And so we might not get the actual documents per se, but a lot of the information eventually, if it continues, if nothing interrupts the case till then, a lot of the information will eventually get out there.
Yeah, I think going back to the hearing, I think that I've been in that position where a judge peppers you so much with so many questions, especially when you bring the motion, because it's your burden to prove based on the motion that you have sufficient information to throw back on the non-moving party, and basically it did sound like from your great write-up that that Judge Boulware was hammering the UFC as far as their motion to dismiss. I thought it was interesting that that Judge Boulware just made the decision essentially from the bench. I mean, usually it would take, I thought that, you do it on a Friday, maybe you come back on the week, you think about it on the weekend and you render your decision. It seemed like he knew right away what he wanted to do. I didn't know if you got that feeling when you were in the courtroom, Paul, or not, but it seemed like, based on what you were writing, it seemed like he knew from the outset. And it's always a deflating thing when you draft a motion and you knew from the outset that this does not look good. I got an uphill battle to do. So, I mean, it sounded like that. Did you get that tone in the courtroom?
So there were different parts. In the beginning, he was really hammering them, and then he kind of eased up and was listening to arguments from the middle and end on. So at that point, it could have been he just didn't believe the beginning arguments and maybe had a decision to make from the middle on, or he made up his mind from the beginning arguments and just didn't care as much, right, to hammer them as much from the middle on. And I think it ended up being the latter. Right, yeah. But the UFC, they also, what they did is use this opportunity to expose them to the things they're going to be saying, like basically calling the venue, TV contract, and what else, sponsor claims absurd, right? And trying, you got their first taste of trying to turn Dana White's quotes around. Mm-hmm. So what the judge was really interested in Dana White's quotes. And he's called them smacking of monopsonistic and monopolistic, content, right? Mm-hmm. And but then every single time you bring one up, the UFC always tried to say he's not talking about competition as a whole. And this is actually something we end up talking about when you do antitrust. They're like, he's talking about a competitor, like that specific competitor, and they're like, that's what you're supposed to do. When you're a competitor, you're supposed to want to put them out of business. So they kept trying to flip it around. So even though they clearly lost, what you could kind of tell they're doing is trying to at least set up some of their future arguments.
I want to pat ourselves in the back, because I remember everybody said when the case came, a lot of people said, oh, it's never going to get past it. It's absurd, this case. And we said it's I think all of us said like 80-90% it's going to get past dismissal. Even with the Twombly Bell Atlantic standard, where you have to make it plausible, not just possible. And it doesn't mean the case is guaranteed 100% either way, but like when I first got the case, I brought it to a bunch of like professors and antitrust attorneys. They all said it's going to pass dismissal. They thought easily, because if you look at it, all the stuff brought up in it is stuff that happened in pre-existing antitrust cases. They brought up stuff from the USA versus International Boxing Club of New York. They brought up Dana White's quotes, and everybody laughed at it, but those were specific because the whole point of that original complaint was to get past dismissal. Now they got to prove it. So this is the part where it gets interesting. Are the accusations accurate, or are they just was that just just filler, just comments by the UFC. So the dismissal, no one, if you listened to our show, you should have been surprised by dismissal. We knew it was coming. Now comes the hard and more interesting part. Can they prove it, and can they get past class certification?
Yeah, so I clearly biased, of course, UFC attorneys were like, oh wait, I don't know if I should say that. I can't tell you exactly what they said, but they're skeptical at class cert, but they also thought they were going to win the Mazie argument and didn't win that. So who knows? What I had something I was just going to say. Something I was just going to throw in and can't remember. Damn it.
Sorry. Yeah, I didn't think they'd win. I mean, I don't know anything, but just talking to people, I didn't think they'd win either one. But that doesn't mean anything in the future. To my, people shouldn't read too much into this too, because there's still a lot to go.
So another thing I asked both sides, which this won't mean as much to a bunch of people yet, but eventually it will, is what's their line on any expert witnesses? Mazie wouldn't give me anything, right? And I knew that the UFC people had worked with the guy I talked to you about, the guy I think that is the best expert witness you can get, Kevin Murphy. And so I was like, are you guys gonna do Kevin Murphy? And I swear, like, if I was at the poker table, he gives this little micro expression. He's like, we worked with them before, but they give this micro expression, little. I don't know. If they get Kevin Murphy, that is seriously. I know I'm doubling down on this statement, but that is seriously not good. But we shall see. We have we'll see in like a year or year and a half or something like that.
There's a lot to come out in the future. But it's I remember I butt dialed one of the Boy Schiller guys once. That was terrible. He was very polite. We had a nice talk.
So anyway, wait, really quick. What? Any thoughts on why? We're familiar. So just to make it clear, what was going on with Mazie? The UFC was trying to exclude him, saying that he was either a competitor or adverse, right? In his role with the MMA-FA, the Mixed Martial Arts Fighters Association, and the hearing ended up being, I can see information about it online, but I was this close. I had a reservation to fly out there that day too and cancel at the last minute. I know, but now I wish I did, right? Because the transcript's online, but you don't have access to it yet. And you can see that the hearing lasted for 40 minutes. I believe it was around 40 minutes. I don't know if it was all that discussion, but they ended up saying that Mazie can have access to things. And so any ideas on what that might have been? Because it could be a few things to me. It could be that they didn't believe that Mazie was the MMA-FA. It could be that they didn't think the MMA-FA was a competitor or even sufficiently adverse. Or it could have been, what was the other one? What's another one that I'm missing? I don't know. I just lost it.
My guess is it's the second. It's that that's my. I mean, I've been trying to get a hold of Mazie because I'm trying to do an interview with the MMA-FA guys. But I think my guess is that it's. I think Corey said something about this on Twitter too. That maybe that being an association is naturally adversarial, but it's not a competitor. I think he said something like that on Twitter. So that seems to indicate that impression or that would be why the decision was made that way.
Oh, so I remember, and to add to what you just said. So what one of the arguments being made was that even when you're adversarial, right? Like if I'm a company and you guys are my suppliers, right? And you guys meet in a room and fix prices against me. I'm the buyer and you're the suppliers. Then we're not competitors, but we do have an adversary relationship. I want to get a lower price from you, and you want to get a higher price from me. That in those price fixing cases, I can't sue you and have access to your confidential information, right? So that type of adversary relationship does not get access to confidential information. So it had to be, so with respect to Mazie, it would be that maybe they were adversarial, but not to that level, or do you know what I mean? So it doesn't always have to be direct competitors.
Maybe you guys know, but Jason or someone knows that I think it also has to do with the effect of having an association. You're allowed, it's considered an adversarial position. I'm trying to remember. I think there's cases when the NFLPA used to file antitrust suits at the NFL all the time, and their attorneys. I mean, back in the 50s, 60s, 70s, that's all they used to do. That was their tactic, was filing antitrust suits against the NFL. And I think it kind of goes in that line that even if he has an association, he's trying to make an association that's adversarial, but it's not quite the same as an actual competitor.
Well, yeah. So I think it was maybe the latter there, where he's not a direct competitor. They are, maybe adversarial on opposing sides, but maybe not directly adversarial. I also thought that it was interesting that how Macy phrased his declaration, in that he wasn't saying he's trial counsel, but he was coordinating with the attorneys. I mean, he's coordinating with the fighters, because obviously, if he had said he was trial counsel, I don't think there was any doubt that he gets to see the documents. There's, if you're saying you're trial counsel, you're inhibiting the right to have fair trial on behalf of your client. So anyway, I do think that that maybe Judge Bulwer didn't think that MMAFA was that direct of a competitor to the UFC.
Yeah, just to clarify really quick, this one was the magistrate judge, not Judge Bulwer.
Oh, I'm sorry. Excuse me. Yeah, the magistrate. Sorry about that.
Yeah, my take on it is I think if the MMAFA was beyond an association and was an actual union, and he was the head of that union, right, and then there's collective bargaining and whatnot, I doubt he would have got access. I think he would have been excluded. So it seems to me that it had to be the judge thinking that, right, one, the MMAFA isn't a union yet, not even an operating association, I don't believe. And then two, it's not crystal clear that he's the head of it. So I think, even though he has a Twitter account, but
and he filed a trademark for it apparently. So.
Yeah. So I don't know. Maybe the judge thought that he was the de facto head of it, but it wasn't at the level of being high enough adversarial, right? If you're not.
I think their argument is that even though they're adversarial as an association, they're not trying to displace the UFC.
Right.
Yeah. Not direct. In fact, technically, if you have a union or association, you want to see the business do as good as possible and just take as much money as you can from that business in the future. That's so you're not trying to compete and displace the UFC or another promoter or the NFL for the NFLPA. You're just trying to negotiate as big a chunk as possible later. So I guess they're competing for a slice of the pie, but they're not competing over the pie.
Yeah, well, they were focused. There's always focus on competition, but when you're a buyer from suppliers, you're not trying to displace them either, right? There's got to be some level of adversarial, whatever. Yes, is that a word? I don't know. Adversariality.
We really stumbled into something that's really outside our expertise.
Anyway, he's in. Yeah. That's all that matters.
Yeah, that's good.
And if the case goes far enough, now we can look to see. I'm sure it's funny too. I'm sure all the fighters that are in it are going to be really popular with other fighters when the discovery starts, and people are getting calls. Hey, can you tell me anything? What's going on?
Oh my God, I already said that to all the attorney guys. So it turns out I just randomly went to a Starbucks, and it happened to be the one where these attorneys are hanging out. I'm trying to get internet access to upload the story, and I'm just sitting there. Then ended up talking to them like, I'm so jealous of you guys for one main reason. You guys get to see like everything, right? Within a few weeks, a few months. I mean, it's not the most fun job in the world, but you get to pour through everything. That's pretty cool.
Oh, well, see, that's where I think it's because I have been on that end of where you get to see everything, and when you see everything, you see everything. So I mean, I've been on like big cases on the, where they're saying voluminous amounts. There are, I kid you not, you get everything. I know that in some of the letters back and forth between the UFC and the plaintiffs' attorneys, they're talking about whether or not email parent trees, where you're just replying to the email, should be included. So that could almost quadruple your amount of information you're looking at, because you could be looking at, and I've done this before, where you could be looking at an email like 4 times because someone's replying to it, and so I mean there is like, I mean, as a young lawyer, I've done these projects where you could go days on end going through somebody's just emails, and you just email after email, and it's funny because it's now shaped of how I send emails, because like I don't put like you will see a lot I'm sure the attorneys will see a lot in the discovery, a lot of come see me, because they know they don't want anything to be put on an email. And then, I mean, I'm sure, but what will be interesting through this process, and I think John alluded to it, there'll be instances where there will be emails from people where you will, I mean, I don't know how many hot docs you will see, but there will be documents that will be like, whoa, you know, this person is placing out his contract, or they're talking about X, Y, or Z, that kind of thing. I think it's similar to, I think for most folks, you know, how Tom Brady had to send over his phone. I think all that information will come out, and you're kind of like, well, there's a lot of minutia here, but you know, in the minutia there will be stuff.
Yeah. Oh, good.
The thing you forget, Paul, is you're all excited because they get to see everything. These are people that don't care about MMA. And
I know.
Exactly.
They're looking at this like this is a terrible nightmare job, but they got to look at stuff that they have. Like, great, I got to go through this. Another fighter contract, same thing, 300 times in a row.
I'm trying to convince them of how cool it is.
Yeah, they're like, yeah, I'll let you do it for free.
I know. Yeah, I had the same experience. I stopped doing this stuff, right, as expert witness support when everything was still in boxes and wasn't always electronic, and it would just be reams and reams of boxes you're going through, and depositions you're going through, and all these hard copy documents you're going through and trying to find things and keep it all organized. So it's going to be a lot easier these days. I imagine that most of it's electronic now, but yeah. There should be some sort of hot doc type quotes coming out. I've worked on price fixing cases where there's some email and they say, we assure you, believe me, we're not trying to compete with you for this contract. And it just looks bad. The old Microsoft case had a famous one that they want to like cut off Netscape's air supply, right, in like a corporate memo. So I expect some sort of stuff like that.
I'm expecting where people's nicknames will get in the way, where they'll say something like, "We're gonna, you know, let's kill this guy." You don't know that's his name. He's the killer. We're gonna. People will be thinking like that's their phrase for. They say they're trying to kill competition right here. No, that's the axe murder we're getting competition. But okay, no, you guys in the legal mind, you guys are more used to this stuff. What, I guess, for the people out there, the layman, what should happen next? What are we going to look for? What's the timeline for the next major event? What, 2017? What do we?
Well, you know, I think the discovery process, it's going to take long, and you know, they had talked about just rolling out the document production in a couple phases, and you know, if they're talking about tons and tons of emails and documents and contracts and whatnot, we could see. I mean, it could be a long time before, you know, we get anything substantive as far as getting to the point where they can get to depositions and such. I mean, I'm not sure. I mean, like a lot of this is going to be e-discovery and third-party vendors, and like you got to send all the hard copy documents out to them. They have to produce it, and then you know, Zuffa's own attorneys have to vet this stuff because they don't want to just hand it over. They're going to have to like look at it, compartmentalize it, and you know, they might have to go through the part. And I've done this before where you have to redact sections even though you're going to produce it, and like and then it'll be handed over to plaintiffs. So it'll be interesting. I mean, it takes tons and tons of hours. So I mean, I foresee, like, you know, maybe even like if they go out hardcore, you know, maybe start of the summer next year, we start to see maybe inklings of depos being noticed, things like that. What are your thoughts, Paul?
Yeah, no, but this is the part where Joe Rogan's comment about how this could get up to whatever $100 million in expense. I mean, I don't know about that, maybe at the very end of the day, but this is the part where the bills start to add up, are they not? Because all the manpower that it takes to do all this. I'd imagine the main things we'll be hearing in the next few months are anytime there's arguments, any arguments about discovery, or eventually this person came in for a depo and was uncooperative and we want to bring him back in, or that kind of stuff. But we're going to get to, after fact discovery, then we get expert discovery, and expert discovery takes us into class cert, right? And that's the next I imagine the things we hear between now and then are arguments about this, that, and the other, right? And then minor things that we'll touch on. The next major thing is you get all the documents out of the way, you get the experts doing their thing, and you've got your argument about whether the class should be certified. But yeah, we do have a big break coming up, I'd imagine. Unless they just fight and bicker all the time, or we can do little things. Hey, look at this going on.
Maybe we'll have a fist fight in the court. We can write about that. That'd be awesome. But the other thing too, people got to remember too, the class cert's a whole different issue. It doesn't matter if they prove monopoly antitrust violation or not. They also got to get over the hurdle of proving it's a class that can sue together, and then they have to argue, bring all that evidence and prove that so it's almost two different things.
Yeah, and so quickly just to tell people the thing to the one other sense I got, which you kind of already knew anyway, was that the UFC it doesn't seem like people talk about Dana White being scared to testify or do a deposition. And I mean, I know that naturally the lawyers aren't going to tell you this thing, but the feeling I got from them is they're ready to fight tooth and nail, which means we pretty much have two more major hurdles coming up before you can really even credibly thinking about the UFC settling, which would be you have to get beyond class certification. If they don't get beyond that, the case is pretty much dead. And then summary judgment. If they don't get beyond that, the case is dead. And once that happens, then to me, I don't know about you guys, that's when I think maybe the UFC might seriously think about settling. But it feels like they're in it for the long haul, even with the expense.
Yeah, my sense is just that I just got a sense they're definitely going to fight up to class certification and summary dismissal. That's because if even I mean, no matter, this is their business model. If they settle now or whatever, what's to stop someone else from coming in and filing another suit? They've opened the door to their business model, so they're going to fight, and they might very well be convinced that they're 100% the right. That we only know from the exterior what's going on. We don't know behind the scenes. It takes knowing what's going behind the scenes to see what's what the actual result's going to be. But my sense is that they're going to, from all sounds of it, the type of money that's been discussed, thrown around, that just to get a Boy Schiller, someone told me once that when I was asking around that you have to, they would need a retainer of tens of millions to be on this case. So that sounds like people that are planning to, to fight for a while.
Yeah, and real quick, to me, it's kind of like the incentive that they're not necessarily sending a signal to the fighters. It's kind of trying to send a signal to other attorneys, right? That we're going to fight you every step. You have to get past all three of these hurdles where we can win the case outright. And if you can't clear any one of those, you just lost yourself a ton of money, right? You're in this game pretty much. Maisie believes in it, but the other guys are in it to make money, right? To get their 30% cut at the end of the day. And if we fight you tooth and nail and you lose at class cert or at summary judgment, I don't know if it's going to happen, but then wow, that would be a powerful disincentive lit down the line, right? Yeah.
But, very aggressive, very good lawyers that the UFC has. So I mean, I definitely, and they're the lawyers that are with the hindsight of going to trial. So I don't think that anyone's backing down, and it's a high stakes poker game when it comes down to it.
Yeah, and we have to remember too the plaintiff side. These guys are they're going to throw so much money into this case. These are guys that are convinced that there's a pot of gold at the end.
Yeah.
I'm pretty sure too that they. From the way they were talking when I was up in San Jose, that they did not expect the UFC to settle right away either. So they were. None of this is a surprise for either side. This is a good time to be an antitrust lawyer to make some money, I guess, in the Nevada region.
Geez, between that and the NCAA, you're doing well.
Yeah. Down in LA, you got another case with boxing. Jeez.
Oh yeah, that too. Yeah.
Yeah, we all got in the wrong business. Except for Paul, I didn't. I guess he did.
Don't make fun of me when I go to the boxing one, but
I'll be there. It's in LA. I might show up to that. I'm just not going up. I'm not going out of town to do it. It's downtown, right? The court downtown.
Yeah, it's downtown. It's central. LA Central, right?
Yeah. It's downtown. I'll do that. Yeah, the exclusive dealing one, I couldn't pass up though. I mean, I've worked on cases so similar to this. I just had to see how they go down. I couldn't resist.
So, we have one more story to go through today, don't we?
We do, and that has to deal with former UFC fighter Wanderlei Silva, who said some things on Facebook and YouTube about, among other things, that the UFC fixes fights. And as a result of that, the UFC, through their attorneys at Campbell and Williams, remember them, they have filed a defamation lawsuit against Wanderlei Silva based on those comments. Silva's attorneys have recently filed a motion to dismiss, which is set for, I believe, November 3rd. And from what we understand, Zuffa's lawyers have already filed their opposition to it, as well as motion to strike some of those exhibits. So basically, the motion to dismiss from Silva relies on the fact that he has a couple things. One, that he's has litigation privilege, basically a privilege to say the things he did about the UFC. And two, there is no, in the complaint that the UFC brought, that there is no show of damages related to his statements, as well as any approximate cause related to his statements as far as it causing damages. And three, under a Nevada law, anti-SLAPP, we'll have to get the acronym for you in a second here, but basically stating that under that statute.
Okay, sorry, we had a little technical difficulties with Jason's feed. So he was talking about anti-SLAPP in the statute, and he's gonna start over.
Oh, sorry about that. Yeah, sorry, guys. So Silva is one of the other claims he's filing under his motion to dismiss is Nevada's anti-SLAPP statute, and SLAPP stands for Strategic Lawsuit Against Public Participation. And essentially, what that does is that it prevents organizations from suppressing speech when people are speaking out. So basically, Silva is saying that the UFC is suing him just because he's speaking out. So that's what he's bringing the motion to. Those three things he's bringing the motion to dismiss under. And in opposition, the UFC has filed papers stating striking some of the exhibits in Silva's motion to dismiss. So let's start with Paul as far as comments. Have you been able to look at the motion to dismiss? What do you think of it, and what do you think of the UFC's chances of getting its complaint dismissed?
I thought it was more creative than I expected. Right? Basically saying, what are you talking about? Evidence of fight fixing where you normally have none, and you have at least something pointing at Belfort, and then basically saying, I might be. And I'd like to get your thoughts on this as a lawyer, right? I might be part of the antitrust lawsuit, so I'm allowed to say whatever I want. That seems a little bit fishy to me. I get it if you were a part of a lawsuit and saying, look, I'm allowed to speak my mind as a plaintiff, but he's sort of saying, well, it's class action, so I might be part of it down the line.
Exactly. So that's under the privilege, so the litigation privilege, and I think there's a Nevada law which basically says that there is a privilege there, but it's not abundantly open for everybody. And so the question is, he is a part of at the time, the NSAC lawsuit where he filed a judicial review for his suspension from the commission, so he could say that. But basically, the concern, I don't know if he's saying he might be a part of the antitrust lawsuit, so can he say stuff about the antitrust lawsuit if he might be at some point a party? So there's a concern about that.
I'm remembering that. It's real quick. I'm remembering that, right? I didn't mess that up. He has the antitrust one in there.
Yeah, he said.
Yes, he does. He does.
Okay.
When I first read it, I thought he was citing that he was going to sign up. He was going to be one of the plaintiffs or something in that. Right. When I read the first time, like, oh no, he's saying that he's potentially, and I'm like, well, that's a stretch. If he was actually part of it, maybe, then I think he'd have a stronger case. But I did think you're right. I think it was a much more, it's a much cleverer defense than I thought it'd be, because when you think about it, he's citing, the Deadspin Josh Gross article about Peter Belfort, and he's citing his own case where he talked about how he was injured and they paid him more to fight. We're offering him more to go and fight when injured. And David Bixenspan brought up how this is very similar to the complaints that people have about pride fights being fixed. Pride fights weren't fixed just because they're like pro wrestling fixed matches. Remember, people would say that they would line up people for Rampage to beat up on 3 weeks' notice, or that other guys would know, were allowed to cheat and others weren't. All these things that gave a guy an advantage. It wasn't a straight, clear-cut, fixed match in Pride, but one guy went in with an obvious advantage over the other guy, and everybody referred to Pride matches as fixed. In the same way with the Elite XC with Kimbo and Seth, when Seth was supposedly offered to stand up against him. And he's I think he kind of opens up that this is a world he can bring up all this stuff and say, listen, I don't know if he's going to go this way, but it just felt that that's the kind of defense he's going to build and say, when I say fixed, because I'm Portuguese and fought in Pride, that I mean fixed, I meant that one guy is given a clear, a clear advantage over the other guy. And, doesn't people always say that about Pride, that that's why it was fixed? That's what I imagine, because I'm sure there's like 30 or 40 articles already out there, or videos of Joe Rogan talking about how Pride was fixed because one guy went on there with a week's notice.
Yeah, I thought that was a creative argument. I don't know if all of that would fly, given that the UFC could just say there's commissions to make sure these are fair fights. But the hiding injuries part seems, you know what I mean? They encouraging people to fight injured and maybe lie on their forms or something like that.
Well, I mean, correct me if I'm wrong. I mean, Jay, he doesn't have to. He could be technically wrong, but if he's speaking what he thinks is the truth based on the evidence he knows, they'd have to prove he's willfully trying to malign the UFC, right? So if he could bring that up and make it a defense that this is what he meant and that a reasonable interpretation by him, am I wrong or right?
What is that? Was that old Seinfeld episode where George Costanza goes under the lie detector test and they tell him, it's only a lie. Oh no, it's the truth if you think it is. So it's I think what Paul said, it's a creative argument, and now I mean it's kind of you're kind of digging in your heels into and putting your weight into an argument that's tenuous at best, and I think that perhaps he could say that that's the truth to him, but obviously for a defamation claim, truth is a defense, but what is truth? I mean, I don't want to get Bill Clinton here, but like what would be the definition of the truth? And so I think that if you're Wanderlei Silva here, that's kind of where you're going with in backtracking on your statements about fixed fights and things of that nature. I mean, if he cleans it up as far as what that means, obviously, the attorneys for the UFC are going to say, no, this is not what he means. He means that he was implying that, we were actually telling people to fight hurt, or we were telling people to fix fights, that kind of stuff.
But I wonder too. It almost seems like he's trying to play a game of chicken with the UFC, and that with the Belfort story of Deadspin, that they might feel that there's more to it, and that they're basically saying, well, we'll go ahead, but we're going to bring this up, and in discovery, you're going to have to give us more information, and we don't think you're going to do that. That's just a sense I have too, but I don't know if that's true, but that's the sense I got.
Right, and I think that's the reason why they're going to try to strike that from the motion to dismiss, and then I'm not sure. It'll be an interesting evidentiary question when they talk about discovery, because if Silva's attorneys are going to ask for more information on it, are they going to ask it from Josh Gross? Are they going to ask it from Deadspin? Or are they going to ask it from the UFC? Because if it depends on how much the UFC thinks is out there. I mean, or if there is anything out there. Because the UFC will be like, we have nothing. Go pound sand. Go ask Josh Gross for his sources. That creates another issue.
So, we know who they're going to ask.
Yeah. Anyway, it'll be interesting to see a thing to ask on, see what happens on November 3rd as far as how the motion goes, because if it gets dismissed, it'll be interesting. The UFC will probably appeal the decision, but if it gets denied, then we could see Silva be deposed, which would be, I would request that be videotaped. I mean, it'll be interesting.
Paul's already buying his ticket.
Yeah, exactly.
Well, here's the thing I feel bad for about Wanderlei. I mean, how much money do you think the guy has, right? I don't know. Do you think he's incredibly wealthy?
He's got some money, I know that, but I don't think
he has some money. Yeah. Because, I mean, if this gets past motion to dismiss, then the UFC decides when they want to stop suing him, is if it gets past this phase, right? And this stuff's expensive. And, I mean, they could take it, if they get past SLAPP and motion to dismiss and all that, they could take this for a while and then at the very end just say, okay, we're cool, we'll back off if you want to, but you're out all that money of your attorney. You don't even have to take it and get an outcome. I'm sure he just wants the lawsuit to go away. It just makes you feel bad for someone, like, and careful with your words. Mm-hmm. Those words can put that massive expense upon you, and then
well, you were saying
back off.
Yes, you were saying earlier you think the hardest part for the UFC is to prove damages, right? Because there's no.
Well, I think I definitely think that it's a question as to what evidence do they have that fixing fights, his statement of fixing fights is damaging the UFC. Obviously, you could theoretically say it's bad for business, but are there actual damages? Are people saying, I'm turning this off, I'm not buying the pay-per-view because the guy has lifted the curtain of the UFC. He's revealed that it's fake. That would be one of those questions as far as, are you taking it literally? Are you taking it to the literal sense of, the causation here is Wanderlei Silva said something, somebody stopped paying for Fight Pass. That it's as simple as that. I mean, can you prove that? And whether or not a judge determines, and again here you'll see that they'll be hammering on Silva's lawyers in court as far as to prove that verdict. So we'll see. Yeah. Also, I'm sorry. One more thing. Sorry about this. The anti-SLAPP thing, I think, might be also a interesting thing as far as you were just talking, Paul, about how this could get expensive for Wanderlei Silva. One of the policy implications from the anti-SLAPP is the fact that it should eliminate lawsuits that are done to chill speech, freedom of speech. So there you go.
Yeah, and really quick on the damages part. I mean, I don't know how this is going to turn out. But one thing, just pointing out one thing the UFC did, I think one reason they did this in their complaint was they specifically put a focus on Brazil, right? Probably in the damages part to say, yeah, people might not believe him here, but he's Wanderlei Silva, and he's a big presence in Brazil. So they have this full paragraph, it's paragraph 23, about damages from his statements not limited to this country, and that he's a big name in Brazil, or particularly damaging in Brazil, given the UFC's large pool of fighters and fan base. So you can tell that I think they probably are concerned about the damages part too, and that's why they threw in this Brazil thing. It's like, hey, even if you don't think it's a big deal here, over there,
yeah,
I don't know how it'll turn out, but
I definitely think that they'll also stress the fact, he was a coach on The Ultimate Fighter down there. He draws X amount in Brazil. The UFC goes to Brazil X amount of times, that sort of thing. I think that they'll draw that correlation to try to survive the motion to dismiss. I mean, try to defend the motion to dismiss.
Yeah, then they can use the excuse. Our last card with Rafael Cavalcante and Glover Shira bombed. See proof that he's killing our
I would love to see that.
Have you seen? That had something to do with that, but yeah, okay.
Have you seen the ratings?
Put the worst card on possible and say, look at our ratings. What happened in Brazil because of him?
And then we put it on Rampage, Hamill 2 or whatever.
Terrible. Terrible in Brazil. That's 100% blame on him. And that's what I would be doing. I'd be right away let's put our worst card on, and we have evidence that we just lost a ton. But and then also to note in the UFC case, their motion to reorder, they also reposted an article from MMA Core who looked like they supposedly posted something that I might have written, but I posted Monday and they posted Saturday. So that's just to get that out there. few days earlier. I don't know. So that's all I'm going to say on that.
That's why I mentioned your name. Probably shouldn't have. Sorry for that.
Yeah, they don't deserve any traffic.
So real quick, there's something that says what the time frame they were going for, shortening it, is October 14th, which last I checked is today. We're filming this on October 14th. Do you guys know if this went through?
I don't know.
Are they requesting it to be heard today, or are they?
You know how they put in an order, but it says now therefore is ordered, blah, 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 October 14th, but it looks like it's signed, Joanna Kishner, District Court Judge, and there's a signature.
Oh, to hear the motion to strike on the same day as the motion to dismiss?
Defendant Wanderlei Silva's motion to dismiss and special motion to dismiss under anti-SLAPP. So I don't even think this is strike. This is the motion to dismisses. Okay, guys, I was talking about possibly the date having changed to today, October 14th, and we took a quick break and checked online, and we have breaking news that that might be a few days late, but the motion to dismiss has happened in the Wanderlei Silva case, and all we know right now is that it is denied in part. So the most important thing there is not denied in full, meaning at least some part of the case is going on, and they could possibly refile others, although we don't know. So we'll have information in the next few days. But we're not waiting until November 3rd. The motion to dismiss has happened today, Wednesday, October 14th, and is denied in part. All right, Jason. So what do you have to take it away?
So basically, it's interesting what will happen going forward, assuming that the lawsuit continues on. We should expect discovery to occur, and eventually, probably the marquee point of this case is that at some point, Wanderlei Silva will be deposed related to his defamation claims and his claims about the UFC. It'll be an interesting deposition, no doubt about that. So that's something to look forward to. Obviously, we'll probably all of us will try to get some sense of the court ruling, try to obtain that in the next coming days. So stay tuned for that.
All right, wait. Final question for you guys, really quick. If you had to pick one and only one to watch the video of, deposition of Dana White, deposition of Wanderlei Silva. What are you picking?
Easily, Dana White.
Wanderlei Silva, simply because I think Dana White will be coached very well, and he won't say a lot of things, even though he'll want to. Wanderlei Silva, I think I think the best bet is for him to just go and talk. So that's why.
Yeah, that's a good point.
There's no telling Wanderlei what to do.
For enjoyment purposes, it would be Wanderlei. For MMA industry purposes, yeah, it would be Dana White. And the plaintiffs could not wait to get their hand on Dana White. They specifically told the judge that. Sorry, John, go ahead.
I'm actually much more intrigued by the non-Zuffa potential guys brought in, like Ed Fishman or Scott Coker and the other promoter, and I think those might be the most interesting fly in the wall moments to hear what they have to say.
Are we on the antitrust case now, real quick? Yeah.
I thought for both, yeah. We're talking about who we want to hear at their deposition. So,
my opinion is that those guys are actually not just going to be interesting. Those guys are going to be really important. Because remember, all antitrust cases, they have a story attached to them. There's a story of how things should flow, about how things should be going. And when you're when the story is you're raising your rivals' costs and foreclosing your rivals, they should be pissed. And so if they're not pissed, that sort of goes towards the UFC story. If they are pissed, that goes to the plaintiff fighters, right? And so the things they have to say are actually important to see if that story holds.
Definitely. Too bad we can't get tickets for that one.
Yeah.
You can come. You'll be in Vegas for that, sneaking in somewhere.
What if I could, man? Those depositions are the things to see.
We're hoping now that since we took the summer vacation, that we'll do more episodes in the future. More than one every 4 months? Is that the goal?
Yeah. That was probably all my fault
It
too.
is.
I got really busy at one point during the summer.
Everybody 100% blames you. Don't worry about it.
What they're really saying is they're just pissed when we filmed this whole episode and I didn't record it, and they're still holding it against me. No, yeah, this was fun, guys. Yeah, we need to make sure and do it more. And this one's a little bit longer because we've been off for so long. But if we can do it more on a regular basis, we'll keep them shorter.
I think we're gonna also try to talk more about the different aspects of business, just the courts. The court stuff's kind of taken over lately.
Yeah, it really has.
It's a lot of stuff. Yeah.
Yeah, I should have got a law degree. I don't know what I was thinking.
I mean, interesting timing to come on board and have this major, huge lawsuit happen. Oh, and then other things is we think it's so big, right? And then I'm sitting there talking to security guards, like they have no idea what's going on. Like, guys, it's this huge lawsuit in MMA. And they're like, what? Huh?
Yeah, no. In MMA, most people, I think a lot of people have no clue what's going on.
I know.
This is all about the future of the sport. Yeah, okay.
Like, this is UFC. This is Zuffa being sued by their fighters. They didn't care. Could care less. They were looking out about Everything is Beautiful or Life is Beautiful Music Fest and how they were going to get home.
It was a Friday afternoon, to be honest.
Yeah. How are they going to get around traffic?
If you want to see how far MMA has to go before it gets mainstream, just start talking to people about these cases. If it isn't Ronda Rousey, no one cares about it. That's the truth. If it isn't Ronda, we need Ronda to get sued because then we have something to talk about.
Just wait.
That'll be our biggest episode ever. I'm telling you right now, people. Ronda gets sued. That'll be our biggest episode.
The problem is
she has been.
She has been. We haven't talked about it though. We need back in the limelight.
Yeah.
Her and her management.
We wouldn't be the only ones on it then. The beauty of this one is it's big enough where we're like the only people who care about it. Well, not care about it, but the only ones really on it. And we don't have to compete with all those other major outlets who could come and just destroy us.
Swoop in. They can put resources on it.
Yeah.
We don't have to worry about ESPN and New York Times coming in and taking our thunder on this one. We own it.
Right.
Shit.
All right.
The lawyers know you on a first-name basis, for God's sake. That shows you how much you own it, Paul.
And I will repeat that both sides are very nice to talk to in person. I'm sure you don't want either side messing with you, but when you talk to them in just a friendly way, they're both great. Both sides.
You make it sound like they're animals and they just are in cages.
If they were questioning you, you would think they were animals, would you not?
I thought it sounded like the dating game. He's like, on this side's Eric Kramer, on this side's John Cove. Who do I choose? I don't know. You're both so dreamy. So, yeah, I'm sure, yeah. We've lost the 12 people we had remaining on the show. So.
I know, they're like, are these guys ever going to finish?
Yeah.
Okay, we will be back another time with more. On behalf of John Nash and Jason Cruz, I'm Paul Gift. Ask you to support MMA and keep doing business as usual. I can't say that without it. I got to find a way to say it with a straight face.